What is the best way to leave nominal amounts of money to a minor child? Hi, I'm Alec Osland, an attorney at Yanowitz Law Firm, where we've been assisting families with wills, trusts, and probate for over 30 years. Leaving money or any assets to a minor child is something that's pretty standard and straightforward with someone's goals as they plan their estate plan and they're deciding what they want to happen when they do pass away. When we're prepared to leave a large amount of money for the benefit of a minor, we generally leave it into a trust and we appoint a trustee who manages those assets, and they have a fiduciary duty to the minor beneficiary. They use those assets for the minor's health, education, maintenance, and support. Once that minor child reaches a certain age, that trustee generally distributes the remaining trust assets to that child, and that child can use those assets however they want. Now, this type of trust is something that is generally drafted in someone's will or in their irrevocable trust. Now, that type of plan works great when we have a lot of money going for the minor's benefit. But what happens if we just want to leave a smaller nominal amount of money for a minor? Does it still make sense to set up a plan like that? Now, before I kind of get into that, if there is one takeaway from this video that you have, it is please, please, please do not name a minor child as the beneficiary on any life insurance or any type of financial account by just listing their name. Please do not do that. Do not just put this asset goes to John Doe and when John's 10. Do not name a child as the beneficiary on an account and not have anything else. To answer the question of what happens and what's the best way to leave nominal amounts of money to a minor child. So if we want to leave that nominal amount, we're going to utilize a designation under the Minnesota Uniform Transfers to Minors Act. This is commonly referred to as UTMA, an UTMA designation. Under these designations, we name that the asset should pass to the guardian or a custodian of the minor, and they're going to collect that asset as the custodian of the minor child. An example of this would be something along the lines of, I leave $25,000 to Jane Doe as custodian for Billy Bob Doe under the Minnesota Uniform Transfers to Minors Act. In that situation, Jane is the parent, Billy Bob Doe is the minor child. So we're leaving it to the parent as the custodian of the minor child under the Uniform Transfer of Minors Act. So this is something that we can draft in your will or your trust as under a specific gift, or we can actually use this language in the beneficiary designation forms for your financial account. So that's great. What does this mean and how does it work? Essentially, this allows the custodian, who's generally that parent, to collect that financial asset on behalf of the minor child. They then can use those funds for the child, what's in their best interest. They can spend them, buy them a car or something like that, but it's funds to be used for the minor child. Once that minor child turns 21, they then take control of the assets and they get to use it how they want. There's no restrictions on that. A benefit to a UTMA account and designation like this compared to the distribution in a trust is a distribution in trust is going to be required to file an income tax return every year. If we have a lot of money that's going to a minor child, we do want to utilize the trust as it's going to offer a lot of protections for that child with liability. But if we just have a nominal amount, we can go ahead and use the UTMA designation to accomplish the goal of if we want to pass a nominal amount to a minor child. So with that, it's very important that if we're utilizing that UTMA language, that it is done correctly, because if it is not, or if it's not included, it could cost thousands of dollars to petition a court and have a court grant an order to collect those funds on the minor's behalf. So whether it's utilizing the UTMA language or just drafting your estate plan in general, it's very important that you work with an attorney who knows what they're doing and who has the expertise in this area, because we don't get a trial run with estate plans. There isn't an undo button, and we don't know if a mess is made until it's too late. We can't do anything. So I'd like to thank you for joining me today. Make sure you subscribe to our YouTube channel to find out when we post another video. Thanks. Have a great day. Bye.